Breach of contract. Understanding breach of contract. A brief definition of breach of contract is when a party fails to perform their responsibilities under a legally binding agreement. Importance. Contracts facilitate fair and mutually beneficial economic transactions, offering legal protection and predictability to all parties involved. This presentation provides a complete overview of breach of contract, covering numerous forms, real-world instances, legal implications, potential defenses, preventative methods, and developing trends. Types of contracts. There are two types of contracts, express and implied. Express contracts are formed when the terms are explicitly stated, either orally or in writing. An example of this could be direct communication. Implied contracts are derived from the conduct or circumstances surrounding the transaction. Legally binding. To be considered legally binding, the parties involved must have the capacity to do so. This excludes minors, the mentally ill, and those who are intoxicated. The contract must also serve no criminal or immoral purpose or violate public policy. Overall, these elements ensure that a contract is valid, enforceable, and legally binding to all parties involved. Breach of contract defined. Breach of contract is a legal concept that occurs when one party fails to meet its obligations under a legally binding agreement without a valid legal reason. This failure can result in legal consequences for the offending party. Occurrence. Contract breaches are typically minor or material. A minor breach occurs when you do not receive an item or service by a specific due date, whereas a material breach occurs when you receive something other than what was specified in an agreement. An example of this would be you needed gold, but you did receive silver instead. Real-world examples. Jerry's Hardware LLC versus Hillcrest Partners. A quick overview of this case. Jerry's Hardware LLC versus Hillcrest Partners. The Court of Appeals upheld a breach of contract decision regarding a commercial lease. Hillcrest Partners initially agreed to construct a building to meet Jerry's Hardware's specific needs, but financial constraints prevented the project from moving forward. Despite investing $100K, Jerry's Hardware received no response to the delay and suffered major losses. They filed a lawsuit for compensation. Nature. The contract in question is a commercial lease agreement. Jerry's Hardware signed a lease agreement with the defendant Hillcrest Partners for a commercial space. Specifics and consequences. Because the defendant failed to fulfill their portion of the agreement, the plaintiff filed a lawsuit against them. The plaintiff was awarded $100,440.77 in damages to cover a variety of accumulated costs. Additionally, the plaintiff must find a new building location, and purchase new equipment to suit the new building.
Legal consequences. The legal remedies available to a non-breaching party in a contract dispute include damages, specific performance, restitution, rescission, reformation, and equitable remedies such as injunctions, each aimed at compensating for losses, enforcing contractual obligations, or restoring parties to their pre-contractual positions. Damages are the most common remedy for breach of contract. When one party fails to fulfill their obligations under contract, the non-breaching party may seek damages to compensate for the losses they've suffered as a result of the breach. There are several types of damages that may be awarded. First of which, compensatory damages. These are damages aimed to compensate the non-breaching party for the actual financial losses incurred due to the breach. The aim is to put the injured party in a position they would have been in if the contract had been performed as agreed. Consequential damages, also known as special damages. These are damages that result indirectly from the breach and are foreseeable by the parties at the time of contract formation. For example, lost profits. Punitive damages. These are damages awarded to punish the breaching party for particular egregious conduct and to deter similar conduct in the future. However, punitive damages are not typically awarded in contract cases, except in cases involving fraud or intentional misconduct. Liquidated damages. In some contracts, the parties may agree in advance to a specific amount of damages. This will be payable in the event of a breach, or if one defaults. These are called liquidated damages clauses. Courts will enforce liquidated damages clauses if they are reasonable estimate of anticipated damages and not a penalty. Specific performance. Specific performance is an equitable remedy for where the court orders the breaching party to fulfill their contractual obligations as specified in the contract. This remedy is typically available in cases involving unique goods or services where monetary damages would be inadequate to compensate the non-breaching party. Specific performance is discretionary and may not be granted if it is impractical or inequitable to do so. Restitution. Restitution is a remedy aimed at restoring the non-breaching party to the position they were before the contract was formed. It involves returning the benefits of or payments received under the contract to the non-breaching party. Restitution may be awarded in addition or instead of damages. It is commonly sought in cases involving contracts that are void or unforeseeable, or in cases where parties has been unjustly enriched at the expense of another party. Second real-world application, Marvel Entertainment LLC and Edward Norton, breach of actor contract. So let me run down a real quick overview of the case. Actor Edward Norton was initially cast as Bruce Banner and the Hulk in the 2008 film The Incredible Hulk, produced by Marvel Entertainment. Norton had signed an actor contract to portray the character in multiple films, including the Avengers franchise. Now, following the release of the film, Edward Norton wasn't exactly an optimist. He saw the character going in a different direction than the producers and director. And he voiced his opinions often on set. And there was like a lot of disagreements and disputes on set while filming. And, you know, he wasn't exactly happy with the final cut of the film. So when he went on to participate in promotional activities for the film, he kind of badmouthed the producing and, you know, how it came along. So he was at that point penalized by Marvel, and they filed suit against Edward Norton for the breach of contract, and they wanted to seek damages for his failure to fully fulfill the terms and agreements of their contract. So the parties eventually settled the dispute out of court, with Norton reportedly receiving compensation for his work on The Incredible Hulk, but not reprising his role as Bruce Banner in the future films. The actual specifics of the case, because of the confidentiality clauses and negotiation strategies that were settled in court, are unavailable to the public, which is probably for the best, because I'm sure there'd be a lot of like angry fans out there for how Marvel had dealt with it. But yeah, it's quite entertaining. If you are interested, and you should go and check out Joe Rogan's podcast. He actually has a great interview with Edward Norton about this subject and about how he saw the character going in a different light. In retrospect, I thought that was quite entertaining, and it's kind of interesting because they mentioned the contractual obligations with Marvel as well. So if you're interested. Defenses against breach. Impossibility. Impossibility refers to situations where performance of contract becomes objectively impossible due to unforeseen circumstances beyond the control of either party. This could include the events such as natural disasters, government actions, martial law, death, incapacity of key individuals necessary for the performance of the contract. When impossibility arises, the party affected by it may be excused from performing their contractual obligations. Frustration of purpose. This occurs when an unforeseen event significantly undermines the fundamental purpose of the contract. Now, the contract is rendered worthless, but it's not impossible for the contract to be fulfilled. So that's where impossibility and frustration of purpose kind of differ. Courts may excuse non-performance or modify contractual obligations in cases of frustration of purpose, but unlike possibility, which makes the performance objectively impossible, frustration of purpose arises when the performance remains possible but serves no meaningful purpose. And finally, a waiver. A waiver occurs when one party voluntarily relinquishes its right to enforce a particular provision or requirement of the contract against another party. By waiving their right to enforce contractual obligation, the waiving party effectively excuses the other party's non-performance or deviation from contract terms. A waiver can be explicit, such as a written agreement or a statement, or implied through the conduct or actions of the waiver.
Hi everyone. Today I'm going to talk about the strategies to prevent the breach of contract. First, it is essential that we write a clear and detailed contract so that we can avoid the misunderstanding and conflicting relationship and expectation between parties. It is crucial that we write contract precisely and clearly define the rights and obligations of both parties, including the specific timelines and deliverables, and make sure that all the terms or languages that we use in the contract are clear and easy to understand for both parties because poorly defined expectations can lead to misunderstanding and conflicting relationship or interpretation between parties, which can lead to a breach of contract. Number two is perform or deliver as agreed in the contract. It is essential that both parties has to do some research about the other party so that they know that the party that they are agreeing with is capable or they have the ability or capabilities to comply with the obligations or to the obligations that assigned to them. So it is important that they can rely on the party. So it is important that we assess and do some research and also establish the realistic expectation. It is important because having too high expectation can result to a impossibility to achieve the obligations or expectations. So make sure that the expectations of both parties are realistic, that it is achievable. And we have also to include the provisions or remedies in case one of the party failed to perform. Make sure there's alternatives that they can do to cover up the mistakes that they did or the failure of performing the obligations. So having a provisions or remedies is really good in the contract also. And then third is regular communications and your documentation is also important to prevent the breach of contract because having a effective communications throughout the contract and if there are any changes or any amendments in the original contract or any important interaction between parties or verbal talk that is necessary, make sure that everything are documented, make sure that they are write down everything um so that they can enforce the term later on, and also they can use it as evidence in case there's a what do you call it? In case there's a dispute. So doing that, having a regular communication and documentation can lessen the misunderstanding between parties, so it can avoid the breach of contract. Fourth is carefully review and understand the contract before signing the contract. For both parties, they should make sure they understand thoroughly and they comprehend what is in the contract because sometimes it happened that the party are just rushing to sign the contract without even knowing or understanding the contract, which can lead to a breach of contract. So make sure that the party understood, they know what they're getting into, they know they're fully aware of their rights and obligations. And if they don't understand what the term or what is the contract about or what it is saying, so they can seek a legal advice from the lawyer or attorney or to anybody that can clearly explain to them what are the contract about. So it is important before that both party before signing the contract so it can avoid the breach of contract. And then five is incorporate a dispute resolution mechanism. It is important that both party have the outlining steps in case one of the party failed to perform or there's a dispute or disagreement. So at least they have choices what the preferred method to do. Like they can solve it by themselves, which is and they can negotiate, or they can do the ADR, which is the alternative dispute resolutions, or the litigations, which is can be expensive. We have expensive and it is costly and time consuming. So if they can do the negotiation or alternative dispute resolutions, which is easiest and can save them time, then that would be great. So it is important that they have the outlining steps, what to take in case one of the party failed to perform. So these are the strategies that we can use to prevent the breach of contract. Contract is the foundation of business and professional and transactional relationship. Having clear terms and detailed in contract is an essential tool and crucial for the growth and success of business due to it can help us prevent disputes. And also, contract outlines all the conditions and obligations that are necessary for both parties. I said that it prevents disputes and conflicts because once the term and conditions or the detail in the contract ensures that all parties have a common understanding of their agreement, which help prevent the conflict because the main reason why the conflict arises is that if there's an ambiguity between terms or languages that are being used in the contract, but if it's clear and it's very detailed, then it can prevent all the conflict and avoid the disputes. It also facilitates if both parties know what to expect from each other, so there's a clear expectation for both parties, then it creates an effective communication. Once there's a effective communication, then it avoids the misunderstanding and it increase the productivity on both parties. It avoid delays and everyone are become more efficient because they know exactly what their obligations are, they know what to do, and they know what to be done. So whatever expectation they expect for each party, it they know exactly how what that they have to follow suits or follow through. And then it protect the legal rights also, having a clear, detailed contract to take the legal rights because uh, let's say there's a dispute between parties, one of the party violates or breach the contract. Those the contract, the whatever is stated in the contract, like terms and conditions, once it is clear, it can be used. The court can use it as a basis for the parties. The court will examine exactly what are the terms and conditions that are stated in the contract. If it's vague, then there's a chance that it can use it against the party who like who violate, or even you're innocent. If the terms and detail in the contract are not clear, then it can become like a it can become a void or not a like rebuke. So it is important that the detail are really clear. So once one of the party failed to deliver or comply with the obligation or do the obligations or fail to perform, then you can use your legal rights because you have the clear detailed contract. So yeah, so what that's what it protects that's why it protects the legal rights. It also enables impartiality. So once the both parties sign into the contract, it means they agree that whatever the terms and conditions that are stated in the contract, that means that both parties agree that they will follow those agreements. So and they know exactly also that if they don't follow the agreement and they already signed the contract, that means that there's a consequences. That means that they breached the contract. So the contract become enforceable because um it has a once it has clear and detailed contract, it become enforceable because both party knows exactly or they both understand their obligations that they have to follow that are in the contract. Also, having a clear, detailed contract also build trust among parties because once there's a clear communication, clear terms and conditions, everything are clear and everything are very detailed, then more likely that the party will trust the other party, and then it will create a good relationship. It will create a solid relationship, and then they can trust each other more. But if the details are ambiguous, then it can start a misunderstanding, and also it can create a conflict and a dispute for both parties. So having a clear detailed contract can help it is obviously can create or build a trust between parties. So these are important. So having a clear and detailed contract can really prevent any breach or a conflict between parties. Lesson learned. So both scenarios prove that contracts play an important role by ensuring that both parties sign the contract because they both understand the legal terms and obligations when they get into an agreement. So once they sign the contract, it ensures the legal protections of both parties who upheld in the agreement. However, the party who failed to follow or deliver in accordance with the contract terms and conditions said that party breached the contract, and whoever breached the contract will face the consequences or legal consequences. So even there's a contract, it can still be broken by any party who are involved in the agreement. So there's two types of breach of contract, which can be material and minor, depending on which part the party failed to deliver or not deliver in the agreement. So the breach of contract can be resolved by both parties themselves. They can negotiate, or they can do the alternative dispute resolutions, or if they can't resolve it through negotiations and ADR, they can go to the court, which is the litigation, which can be expensive. It's really costly and time consuming. But the innocent party can seek monetary compensations or punitive damage from the party who failed to fulfill their obligations. So a breach of contract is not really a crime. It's a civil case where it still has a legal consequences, but the party is not going to jail. They just have to they may be required to pay damages or compensate the innocent party for failing to perform according to the contract agreement. So basically, this contract protects the party who appeal in the agreement or uh, who follow the terms and conditions that are stated in the agreement, while the other party who breached the said contract or who broke the promise or who did not fulfill the obligation said that they breach the contract, so they are going to face the any consequences like paying damages towards the innocent party. Contract outlines all the rights and obligations of the parties. So once you sign the contract, you promise that you will abide by the terms and obligations stated in the contract. So it is important or imperative that both parties read or review the terms and conditions and make sure that they understand what they are committing to. Make sure that they understand their rights and obligations and that they are aware of the what are the parties expected of them so that this clarity so this clarity can avoid the misunderstanding between parties and uh, once you understand the terms and obligations it creates a clarification about what your obligations, what are the expected, the what are the things that are the terms and conditions or obligations that are being specified in the contract. So if you never read, you never review, or you did not understand the terms and conditions or obligations that you agreed upon or the one that you signed in the contract, then it can be a problem later on because it can cause a big problem or you might put yourself in trouble because of the you're not aware of the you did not understand the contract and the terms and conditions. So you don't want to be in a position where you might get surprised and you are in a dispute or disagreement. So it is important that you understand the contract terms and obligations so it will avoid the misunderstanding and it will avoid the conflict and it will avoid the problem or it will avoid the legal violation or the consequences for not doing what's it your obligations or for failing to perform your obligations just because you did not understand your contract terms and obligations. So before you sign the contract, make sure that you understand them and you know what are the terms and conditions, you know what to expect, you know what to do, so you know what to perform so that way you can have a you can avoid any problem for the future. So it is important that you have understand the contract and so that it can help you identify your rights and um, prevent any legal conflicts for the future. New law that was issued by the state of Illinois called the Freelance Worker Protection Act. This will go into effect on July 1, 2024. This is specifically designed for freelance workers, which it requires the parties to have a written agreement when they hire when they have a contract with the freelance workers, which has value of 500 or more. So the Freelance Worker Protection Act requires the hiring entity or the businesses from Illinois that they have to pay the contracted compensations on or before the due date that are specified in the contract. But if there's no specified date that are stated in the contract, then the hiring entity should pay the freelance workers at least no later than within 30 days. If the business entities pay later than that, then they have to double the amount that they haven't paid to the freelance workers. So for any penalty, there's a corresponding penalty for different kinds of natures of breach. So for violation of the written contract, so the freelance workers are entitled to statutory damages, which is equal to the value stated in the contract, or $500, whichever is the higher, plus other remedies. For late payment violation, the freelance workers are entitled to recover the double the amount of underpayment plus the cost of the suit, and plus the injunctive relief and all the attorney's fees will be shouldered by the hiring entity. And for non-discrimination breaches, the result in the damages is equal to the contract's value in all the total costs that may occur for that for the case for this case, and for all the attorney's fees should be shouldered by the hiring entity or the business entity. So mainly this Freelance Workers Protection Act really is just about protecting the freelance workers so that the hiring entity or business entity from Illinois should be aware of those requirements and requirements so that they can avoid breaching the contract because this the violation seems like it's quite different from like regular contract because it doubled the amount that supposed to be uh, uh supposed the business should pay for the what's it for the workers. So it is important that the hiring entity are aware of those requirements so that they can avoid the breach of contract. So in our modern world, so technology industries become they work hand in hand. They have a great impact to our contract law because of the technology. So many businesses are now more connected than before because from the supplier to the seller to the buyer, we are all connected through the technology, like having a computer. So we buy all the products that we are buying are from the other what's it other country. We use the technology to get connected. So from selling, buying, paying, we use credit card, which is also through the use of technology. So we are becoming more advanced. And the entire process of drafting and signing and managing contracts have become more streamlined and efficient too. So before we used to use to have we used to use to have a traditional business, which we also use paper and we need establishment. So we have to go to some place to do the like let's say to sign the contract or make a contract agreement. So we need paper. But now everyone, almost everything, we can do the signing the contract or creating a contract through online. We can use the electronic signatures, which help us for the rapid execution of contract. We can just sign and then it's valid. Unlike before, you have to be present to the where you are required to go to. But now with the use of technology is becoming more efficient, it's more faster, and then it is actually it's more secure. So it's not just in USA but for the whole world. So it's becoming really more we are becoming more advanced. Many e-commerce now are using different applications and technology to become more efficient, and it's less costly and it is more accurate for executing the contract, and it lessen or minimize the risk than before. Like there's an app like the use of smart contract, which really most financial services and accounting or production industries use these programmable agreements, which can self-execute the predefined conditions once it is met. And then there's a software which called the management contract, also which help us to centralize storage of contracts, making them easy or accessible or trackable. So it monitors deadlines and compliance requirements, ensuring the contractual obligations are met timely and efficiently. And also so I mentioned the smart contracts. There is also what we call the online contracting and click wrap agreements. Like if you wanna upload the app or download the app, so there's an agreement. So you have to agree to the agreement before you can use the app. So these are what we call click wrap agreement. And even like in the like when you wanna rent an apartment, they also have what they call they can use the computer now. You can just agree in the terms and conditions, then sign it with your name, and it becomes valid. So and there's a lot of new software, new apps. The technologies are really like really so advanced, especially with the use of AI, which can so there's a AI driven contract analytics that can use for also for like more we become more diligent in making a contract. So we can use there's also an AI driven contract which we can use for drafting tools as a drafting tools, and then there is AI powered contracts. So all of this, the AI is really like it's transforming and revolutionizing the way we do the agreement and draft and negotiate and execute the contract. So with the help of the AI, we are everything are becoming more accurate, more efficient, and less risk and less costly and more progressive. And then with the everything the business and with the adaptation of fast growing economy, business and the laws are uh, started to work hand in hand so that the laws are adapting to the growing economy and rapid transactions by ensuring that accuracy of the laws and regulations are timely, efficiently executed, and more accessible and easy navigation with all the requirements and updates for smooth and secure transactions that allow everyone to keep up with the fast moving commerce. So even the laws or the creating the laws are becoming more efficient now because of all the technology.
Q&A. So uh, the most enjoyable aspects of working on this project, in my opinion, were actually diving into the subject and the actual material for the real world applications, because it's one thing reading an article or watching a video in class and writing an essay, but actually kind of researching our own subject or for breach of contract and like looking at all to the different intricacies with I mean, it sounds funny now, but with Marvel and how they like dealt with it and what I couldn't find and what was kind of hidden, it was really interesting. Um, and now we kind of have an idea of like what to look for in the future and kind of understand those implications. And secondly, by synthesizing and organizing content related to the breach of contract. Yeah, so by actually organizing this information, kind of what I mentioned before, looking at the actual business law and having a real world application can help us not only understand what to look for in the future, but it also can kind of give us like a good indication of what these types of procedures will look like in the future if we are ever pulled, unfortunately, into one of these things, or we do default on a contract. We kind of have an idea of the different scenarios and things. So, yeah.
Q&A. The most difficult aspect of this project was definitely the organizational factors, such as finding a group, communicating with each other, and ensuring a even workload. Seeking thorough information was also another difficult task. The textbook did help a lot, though. The most important takeaway from this project was definitely gaining a better understanding of business operations and the complexities that exist behind closed doors. Two valuable lessons that will stick with me are the importance of avoiding partnerships with people you know and the recognition that actions do have consequences, emphasizing the need to be cautious and very thoughtful under decision making.
Hi, Professor. We want you to know that this course has taught us a lot of things that we need to know, especially in the business industry. Our weekly discussion and assignment keep us engaged and help us apply our knowledge through understanding, studying, and analyzing them. We are able to learn various things from the foundation of the legal systems to various important lessons that we can use in our daily lives and in our future careers. The topics, references, articles, and videos that you share with us weekly are fascinating and very informative. In addition, we appreciate that you always keep us informed about our assignment and its due dates through your weekly reminders about what's coming up and what needs to be done. You always reach out to help us and look for ways that we can work together to ensure that we succeed in this course. Thank you for the extra credits that you are giving us. It is beneficial to us for giving us some buffers in case our grades are low. This helps us get our feet back to the ground and make up for some lost points. Your kindness, understanding, and consideration is truly amazing. It's a big thing for us to know that you are always there for us and willing to comprehend our situation as students, knowing that life happens sometimes, so that we can work towards our goals, achieve it, and become successful starting from this course onwards. So, Professor, thank you so much for everything.